Ex-spouses complaining about being denied access to their children because of the circuit breaker, and a rise in inquiries by discontented caregivers on how to be given the sole power to deal with assets and affairs of their elderly dependents. Now, these are some of the common issues encountered by one law firm, which has recently started conducting free weekly legal clinics online in response to the circuit breaker measures. And for more, we're joined by Justin Chan, Senior Partner and Head of Dispute Resolution at Tito Isaac Company. Thank you very much, Justin, for joining us this evening. So take us through the rising trend of the types of cases that you're seeing.
Well, as you mentioned just now, divorce inquiries are on the rise. And I think this is due to the enforced 24/7 cohabitation that happens. So at any one time, you are 1 foot away from your spouse or your children, and that may bring forward some previously ignored and deep-set issues. In relation to the ex-spouses being denied access, I think that was to a large extent due to the confusion as to what you could legally leave your residence for, and that has been clarified in recent legislation that says that you are allowed to leave your house in order to take over care and control of your child. Insofar as caregivers are concerned, during the circuit breaker, it could be that previously when elderly dependents were on a rotation basis between two households for their care, now they are only under the care of one, and the other caregiver has taken some issues with regards how that care is being given.
So you're seeing quite a significant impact then that COVID-19 and the situation it's arising, like the circuit breaker measures, is having quite an impact on families then?
I think it's fair to say that there is definitely an impact, but again, all of this is temporary. I mean, come 1st of June, there may be shifts in what kind of control measures are being implemented. So we have to take a wait and see approach.
So, question is, how have the circuit breaker measures then changed the way lawyers like yourself deal with such cases?
It only deals with the delivery system. I mean, most things are done with remote communications at the moment, but our advice doesn't change. If you are ex-spouse dealing with another ex-spouse, the interests of the children remain paramount. If it's caregivers, then that elderly dependent or their dependent's interests are paramount. Our advice actually does not change because of COVID-19.
We do know that there are temporary relief measures, at least, to cover issues like bankruptcy and insolvency. What kind of impact have you seen so far on those types of cases?
I think it's early days yet. The conversation right now seems to address these astronomical numbers of bankruptcy applications that we saw in March of this year. I think it was 462. But it's critical to note that the relief measures only kicked in on the 20th of April. So we need some ramp up time for those relief measures to kick in. So we don't have that crystal ball. The months coming up will be extremely telling.
Justin, we understand that you're doing everything remotely now. So, share with us the experience. How different is it compared to pre-COVID-19 times? And, how has the pandemic actually changed how the legal industry now operates?
We operate mostly remotely. It's very interesting because remote hearings, it's a bit of a change for us because you are no longer physically present before the judge. You are talking through a screen as I am talking to you now. So what it entails is for the judge, I'm hoping it does not differ or detract from the strength of our arguments. For the lawyer, it's very interesting because think of a situation where you can be on your couch 30 seconds after your hearing has concluded. It's a brave new world, and I think we should embrace it.
Well, if we can just keep you from your couch a little bit longer, I've got one last question for you. Do you see a change as well in the types of lawsuits that are being pursued by companies during this period?
Yes, we do. The inclination seems to have gone from suing to negotiating. Previously, where suing was the first port of call, so to speak, now what our jobs seem to be is to review the contract, look at the force majeure clauses, the non-performance clauses, and can we renegotiate this contract somehow? Business continuity seems to be the key. And that is somewhat in line with what our lawmakers are trying to do and making mediation the first port of call for dispute resolution in Singapore.
Yeah, that was a good place to start. Thanks so much for sharing your thoughts with us this evening. Keep up the good work. We've been speaking with Justin Chan, Senior Partner and Head of Dispute Resolution at Tito Isaac Co. Now, fraudulent